Senator Davis, your...
Well, I wouldn't disagree with his notion that nullification is something that ought to be used selectively and specifically. I mean, there are certain issues that rise to that level and some don't. I would take issue in regard to what S92 does. I mean, what it says is that it stands for the long-standing notion that states aren't simply political subdivisions of the federal government. And we have a Supreme Court case, United States, right on point, the Prinz case, P-R-I-N-Z, that was handed down in 1997, that said the federal government can pass laws, but the state is not obliged to spend money, issue its treasurer, or time and employees to enforce them. And that's a long-standing principle. And so that's why you see states across the nation, Virginia, Michigan, Arizona, a dozen others right now, simply saying that, okay, if the federal government says that we're going to hold a U.S. citizen without a trial, without the right to confront their accuser, without an attorney, that state employees and state agencies cannot be compelled to enforce that law. I mean, so the S92 doesn't say that the state's going to rise up in arms and kind of take on any federal official that attempts to enforce that law. But what S92 does say is that states are sovereign entities. They're not merely political subdivisions of the federal government. And when certain things are being violated in the state's opinion, in this case civil liberties, the due process of law, that the state cannot be compelled to spend its money and direct its own employees to follow or discharge that federal law. So it's a very narrow application of the nullification principle, which is really just simply an expression of the overriding theme of our constitutional republic, that we're comprised of two levels. We have the states, who delegated limited powers to the federal government, and that the 10th Amendment, the states reserved unto themselves and the people respectively any powers that weren't delegated to the federal government. So whenever you have a division of power like that, inherent in that structure is the right for the state to look at what the federal government does and to decide for itself whether or not it's acted beyond its authority. And in cases where they do think it's acted beyond its authority, the U.S. Supreme Court has said it's perfectly legitimate for the state to say, we're not going to spend our money or direct our agencies to enforce that law. So there's nothing controversial about this law or this bill. That's why you see it passing almost unanimously on a bipartisan basis in houses throughout the nation. So yes, I think that S92 is a good piece of legislation, and it stands for this notion that we're a federalist republic and the states play a role. They simply don't salute and do whatever the federal government says.
Mr. Davis read, but I'm quoting it right here where it says that no agency of the state may engage in an activity that aids an agency of the armed forces of the United States in execution of 50 U.S.C. 1541 as provided by the National Defense Authorization Act. That tells me that a state agency, a state individuals can't cooperate with the federal government in the execution of that.
I agree with that. We're not going to spend our money. We're not going to have the state taxpayers. We're not going to have state agencies go ahead and participate in a federal law that is going to violate individuals and citizens of due process rights. I mean, that's exactly what it says. And it's modeled after what was passed in Virginia. Other states have modeled after what we're doing here. Again, it's being passed almost unanimously on a bipartisan basis throughout the country. I'm not sure what's different about the South Carolina Senate, but apparently they've decided to make it a partisan Republican and Democrat issue. It's not. It's an issue of whether or not the state can be compelled as a political subdivision of the federal government to fulfill whatever Congress wants them to do. And I just think that, I think that the U.S. Supreme Court has said that's not right.